Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about delay in civil matters. Cases that should have gone to the Supreme Court of Canada, but didn't. In a case involving a dispute between two companies, the disputant filed a claim in court and then did nothing for 9 years. After 9 years, the case was dismissed from court on the basis of the delay in advancing the proceedings. The individual applied to set aside the decision, dismissing the matter on the basis of the delay, arguing that it was unjust to do so, and that application was denied. They appealed unsuccessfully and sought leave to appeal to the Supreme Court of Canada. And the case raises an important question about delay in civil proceedings, specifically about access to justice issues. We already know that there is a huge problem of delay when it comes to criminal cases in Canada. We see time and again cases being stayed because they didn't complete within the required timeframes set by the Supreme Court of Canada. But when it comes to civil proceedings, a large amount of the time, the matters are delayed not for reasons related to the fact that the individuals aren't taking steps to advance the claim, but instead because the individuals can't take steps to advance the claim. And maybe this case may not be that case, but there are situations where it takes years before somebody can have a matter before a civil court judge. And if delay is going to be used to argue that somebody's case should be dismissed, then shouldn't there be an applicable standard for assessing whether or not unreasonable delay falls at the feet of the institution for its failure to offer meaningful, speedy options for the resolution of civil matters, or whether the delay falls at the feet of the individual? There are currently across Canada multiple different practices for assessing whether or not to dismiss for unreasonable delay in different appellate courts across the country. The law is not consistent. It would be important for the Supreme Court of Canada to weigh in on this. While we recognize in criminal cases that justice delayed is justice denied, that same principle does hold true for civil cases too. In fact, civil cases are often the only way for individuals to seek recourse in private disputes. And so when it comes to civil court, if there's nothing that's being done by the Supreme Court of Canada to push the courts and the governments into funding the courts better and to get the operations happening more smoothly, isn't that an injustice in and of itself? The Supreme Court of Canada had the opportunity essentially to do a Jordan rule, but for civil cases, to try and force the government to act, to better staff our courthouses, to better fund our justice system. And unfortunately, they let that opportunity slide by. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.